At 9:23 a.m. sharp, the federal courtroom fell completely silent. A daughter raised her right hand, swearing to tell the truth about her father. What unfolded in the next hours was not political theater. It was sworn testimony detailing deliberate concealment of classified materials months after a federal subpoena demanded their return. I'm Jack Smith. Over 3 decades, I've prosecuted war criminals, mafia bosses, and organized crime leaders. I've seen courtroom tension, defiance, and theatrics, but what I witnessed today was different. It was blood loyalty colliding head-on with federal law. The defense entered confident, armed with a familiar playbook: challenge intent, argue confusion, suggest selective enforcement. They believed the case was circumstantial, that the government lacked direct evidence showing the defendant personally handled classified documents after the June 2024 FBI subpoena. They were mistaken. The first question was precise. Did you personally observe the defendant handling classified materials at Bedminster after the June 2024 FBI subpoena? The answer was immediate. Yes, multiple times. She described folders marked classified, kept in his private office. She testified that he reviewed them even during family dinners. Sensitive documents remained on his desk weeks after his lawyer had certified full compliance with federal demands. Then came Exhibit 184, a photograph dated July 15, 2024, 6:47 p.m. The image showed a private desk at Bedminster with CIA briefing folders clearly labeled top secret. The question was simple. Who was handling these documents when you took this photo? The defendant. In federal court, moments like this shift everything. Posture changes, confidence falters, and the weight of evidence becomes tangible. The defense tried a familiar tactic: sow doubt. Perhaps these were old documents, perhaps the dates were misread, but she unlocked her phone and displayed the metadata. July 15, 2024, 1 month after the FBI subpoena, 2 weeks after certification of return. The ambiguity vanished. This was not accidental retention. This was deliberate possession. Her testimony went further. She described conversations in which the defendant discussed relocating materials before scheduled compliance reviews. She recalled a family dinner on August 3, 2024, where classified intelligence assessments of foreign military capabilities were casually referenced as presidential souvenirs. When you are president, everything becomes yours, even national security intelligence. That statement, made under oath, matters profoundly. Criminal statutes involving national defense information hinge on knowledge, willfulness, and consciousness of wrongdoing. Bragging about possession while federal investigators demand return is not confusion. It is awareness. Then came security footage. August 12, 2024, 11:47 p.m. The defendant, alone in his study, photographing classified documents with a personal phone. "Who is that in the footage?" "My father," she said. Courtroom reactions were muted, but the gravity shifted. This testimony was not just credible, it was devastating. The witness was family, not a cooperating defendant seeking leniency, not an employee seeking revenge. Family testimony carries immense weight. Immunity agreements are not granted casually. They are extended when testimony is essential and exposure is credible. Her agreement covered moving documents and conversations about concealment strategies. One red folder, meticulously described, contained handwritten notes on intelligence assessments. Writing on classified documents undermines any claim of ignorance regarding their sensitivity. During a recess, the defense no longer debated strategy. They recalibrated survival. Photographic evidence paired with corroborating testimony changes risk assessment. The constitutional and statutory stakes are clear. A former president stands accused of knowingly retaining national defense information after a lawful demand for its return. These materials include intelligence assessments concerning foreign capabilities and ongoing operations. This is not political commentary, it is statutory enforcement. Former presidents are not exempt from compliance, and personal libraries are not sanctuaries for classified intelligence. The prosecution introduced a second photograph, time-stamped, corroborated by digital records, showing handling of classified materials in common areas. Patterns matter. Repeated conduct after notice demonstrates intent. The witness's testimony established 3 pillars: timeline, knowledge, and action. When court adjourned briefly, the implications were clear. The defense's narrative of administrative misunderstanding had been shattered by direct evidence of post-subpoena possession. But the most destabilizing portion of testimony had yet to arrive. During redirect, a single question expanded the scope. Were other family members present during conversations about relocating sensitive materials? Yes, names were spoken. The implication was immediate: potential conspiracy. Multiple witnesses, expanded evidentiary net. Posture shifted again. This case was no longer solely about retention. It was about obstruction. Obstruction requires proof of intent to impede investigation, relocating materials before scheduled reviews, photographing documents privately, discussing concealment strategies. All these elements were now on record. The court reporter transcribed every word, metadata, timestamps, images, all preserved and authenticated. The jury will not weigh political narratives. They will evaluate evidence. The evidentiary landscape had shifted. The illusion of ambiguity narrowed. Assertions of total compliance fractured. This testimony did not rely on speculation. It relied on observation, timestamps, digital documentation, and physical evidence. In federal prosecution, clarity, not volume, wins cases. Today delivered clarity. After lunch, the morning testimony's strategic implications became unmistakable. The government was constructing a narrative of deliberate concealment tied to knowledge of federal scrutiny. During redirect, the prosecutor revisited July 2024. Did the defendant discuss handling documents before FBI compliance checks? Yes. She described conversations about relocating materials to avoid detection during inspections. 3 days before a December 2024 review, the defendant instructed her to ensure nothing important in his study could be accidentally removed by staff. Timing matters. Actions taken just before compliance inspections demonstrate awareness and intent. The defense objected, overruled. The witness then described September 2024 phone calls. The defendant allegedly discussed photographing documents for a future presidential library. When she expressed concern, he said, "Everything I touch becomes declassified by my presence." Legally, that statement is significant. Declassification is formal, documented, and agency coordinated. Personal assertion does not substitute for compliance. Text messages from August 2024 reinforce the timeline. Family members expressed concern about continued possession after federal demand, reflecting awareness and intent. Contemporaneous messages capture mindset and undermine claims of confusion or error. Additionally, a voluntarily produced USB drive contained security images automatically captured when classified folders were present in shared spaces. Metadata confirmed timelines, locations, and interactions. What unfolded in that courtroom was not theatrics. It was incremental evidentiary tightening, observation, photograph, metadata, security footage, text messages, and recorded statements. Each layer neutralized narrative defenses. The defense will continue to challenge admissibility, chain of custody, and executive authority claims, but jurors focus on simplicity. Were documents demanded? Were they returned? Were they later photographed, handled, and discussed? Did the defendant know they were classified? The afternoon session also illuminated exposure beyond retention. Conspiracy statutes apply when 2 or more individuals agree to obstruct justice. If multiple family members participated in relocation or concealment discussions, exposure broadened significantly. Emergency consultations during recess were strategic recalculations of risk. When family testimony aligns with digital evidence, plea negotiations often shift. By 4:15 p.m., proceedings adjourned. There were no dramatic gestures, no shouting, no theatrics, only documented evidence entering the record. High-profile cases attract narrative framing, but federal courts proceed methodically, evaluating admissibility, constructing evidentiary sequences, and establishing a factual record. Today was methodical. A witness established presence. Evidence corroborated timeline. Digital records reinforced intent. Constitutional and statutory issues were tested. Former presidents are not immune from subpoenas once out of office. Executive privilege does not cover personal retention of classified intelligence absent lawful basis. Appellate courts may interpret, but factual records are established at trial, and today the record expanded substantially. The testimony will not conclude the case. It opens new investigative avenues. Forensic experts will authenticate metadata. Security logs will be verified. Intelligence officials may testify regarding classification. Defense counsel will cross-examine credibility. Process matters. In my 30 years of prosecution, I've observed that cases often turn not on dramatic revelations, but on cumulative detail. Today provided that detail. Time-stamped photographs, security footage, text messages, statements about concealment, and instructions prior to compliance checks. These details form the structural backbone of prosecution. By 4:15 p.m., the courtroom had witnessed a trajectory shift. At 9:23 a.m., a daughter swore to tell the truth. By mid-afternoon, that truth had altered the course of a federal prosecution. Evidence now dictates the narrative. The law moves forward.